let's discuss about the right to die. So when we talk about right to die, basically the word right is attached. So as far as the right to die is concerned, what does it mean? Right simply implies that some sort of claims or entitlements. The basic meaning of the word right is nothing but if we are entitled to, or if we have some claims. So the claims or entitlements we have for what? For ending our life. That is, die means ending our life. So the big question is, when we say right to die, if we are claiming it, or if we are entitled to that, then definitely it is different from the term which you might have heard is nothing but suicide. Because suicide is also what? Ending of our life. But it is not a matter of claim. Rather, it's a offense, which is considered to be an offense and punishable as well under the IPC, especially section 306 and 309. They deal with the suicide as a criminal act. So we'll study about that also. And especially we'll try to compare the position of India as far as the global situation is concerned, you know, from the perspective of right to die. Now, when we talk about right to die, let's try to understand, first of all, the right to life. Because unless we don't understand what is right to life, then it would be difficult for us to understand what is right to die. So when we talk about right to life, the basic constitutional position or provisions we talk about, then we know that right to die is an antithesis to right to life. And here, what had been actually given to us is right to life, especially in part 3 of our constitution, which deals with fundamental rights. So it is a sort of fundamental rights, and as you all know, fundamental rights are justiciable in nature. So if somebody threatens our life, we have a right to move to the court under Article 32 as well. And the position of right to life is mentioned under Article 21 of the Constitution, which talks about right to life, plus it also talks about personal liberty. So, right to life and personal liberty. So, first thing, we'll understand the constitutional position or provision, and then we'll see how the right to die, you know, came into news, why it was in news, and what is the significance of this particular clause or provision. Now, the first and foremost thing, when we attempt to understand what is right to life, then right to life is considered to be what? One of the most widest amplitude as far as the provisions of the Constitution are concerned under Article 21. Why I'm saying most of the widest amplitude? Because it has been interpreted multiple times by the Supreme Court, and many rights were actually included in right to life or under the ambit of Article 21. So now we have more than 40 plus inferred rights. Inferred rights means derived rights which were taken from right to life. Like, for example, you might have heard about right to food, right to clothing, right to shelter, right to fresh air, right to clean and safe drinking water, right to privacy, right to sleep, right to travel abroad, etc., etc. So like that, we have 40 plus inferred right as far as Article 21 is concerned. Now, what Article 21 says? Article 21 says that as a citizen of India, right, and it is available for all the persons, we enjoy the right to life. But that right to life is nothing but subjected to some conditions. So here, Article 21 gives us right to life, plus it also gives us the personal liberty. Liberty means freedom. That means it's my life, my type kind of thing. But these two are subjected to reasonable restrictions also. However, the article says that it must be what? As per the doctrine of procedure, established by law. So what is procedure established by law? Now, when we talk about procedure established by law, it is a doctrine, or we can say a sort of principle. That means for enjoying the right to life, for enjoying the personal liberty, we must follow the process which is established by law. And in simple terms, because in regular polity classes you might have understood, procedure established by law simply implies anything which is certified by the legislature, executive and judiciary. That is, legislature will make the law related with right to life, executive will implement it, and judiciary will interpret whether that law is as per the constitutional provisions or not. Right. But the problem with this was actually it was very limited or in a narrow sense. Why it was in narrow sense? Because here, when we talk about right to life, so right to life was basically interpreted as right to a mere animal existence. Just the way the animals have the right to life, that sort of right to life was given to us. Something like that. Right. And there was a very famous case also which you might have studied in your polity classes known as A.K. Gopalan. So in A.K. Gopalan case, which was case of 50s, Supreme Court said that right to life is simply what? Just like a mere existence means eat, sleep, repeat, die, and so on. However, the stand of Supreme Court was changed when, the term personal liberty was elaborated, especially in the Menka Gandhi case. So while writing this, you can refer these two cases, just to give the examiner a direction that you know the terms very clearly. It was in 1978 where the ambit of right to life had been expanded and another word was added, that is right to life with dignity. So it's not just a mere existence, but it's an existence which provides a dignified life. Right. So this was around 80s. But in 90s, what happened? A new debate started that what are the ambit of this dignity part? So many things are associated with human dignity and so on. Out of that only, and the debate was also started with, do we have right to die under the ambit of this dignity or not? So when we talk about right to die, see, right to die or suicide, right, is nothing but ending or terminating the life. But there is another way also by the life can be terminated. You might have heard about death sentence, right? So death sentence, or popularly known as capital punishment. So we all know that capital punishment is given by the state only, no doubt about it, right? Hang till death and so on if you perform that crime. So what do you have to understand? Your right to life is secured only till that extent where you do not exploit or take the life of other person. If you do so, then here, because of the doctrine of procedure established by law, there is a law. Procedure established by law means we have a section 302 of IPC which says that if your crime is proved, then you may be awarded the capital punishment or death sentence. So you may be hanged till death or your life may be taken by the state. Is it not the violation of right to life? Answer is no, because of this particular doctrine. That there is a law for that, and without law, state cannot take your life. So if you violated the law, then the punishment may come in the form of death sentence. So that is one thing. Suicide is somewhat like it's a suo moto, or we can say self-initiated. So for suicide also we have laws. I'll discuss very shortly. And then right to die is related with something called mercy killing. The new term used coined for this is mercy killing, or we can say you might have heard about a term called euthanasia, right? So what is euthanasia? What is mercy killing? That part we'll discuss. That is a domain of right to die. So here, what we have to understand that why right to die came into news and how it has started. So when we talk about right to die, that means what? That means it is not equivalent to suicide, right? Let's try to understand this first. Suicide means terminating one's life, as simple as that, right? So terminating one's life. Now, if somebody terminates one's life, then it was considered to be a punishable offense under section 306 and 309 of IPC. 306 deals with the abetment to the suicide, and 309 committing the suicide. That means what? The person who is committing the suicide plus the person who is provoking the person to commit the suicide. In case of abetment, the punishment can go up to 10 years. In case of suicide, if you die, it's fine. If you don't, then you may be punished up to 1 year or some fine as well. So these were punishable offense, right? But the petitions were filed in court asking that, or saying that what is the meaning of personal liberty if we do not have the what right to die, right? So here, what Supreme Court said that you know in a very famous case which was known as State of Maharashtra. So initially, the matter went into State of Maharashtra versus Maruti. So this case was basically where Supreme Court said that what? Sorry, the High Court of Bombay said that it was not a Supreme Court judgment; it was a Bombay High Court judgment, right? That suicide, which is a punishable offense under 309, is what? Unconstitutional. That means we should done away with 309 and make it unconstitutional, right? Then the same thing had been upheld in a very famous case that was known as P. Ratinam case. So P. Ratinam versus Union of India, this was a judgment of 1994 in which Supreme Court actually had upheld the judgment given in the State of Bombay versus Maruti case, right? So that means Supreme Court said that what? That right to die must be included under the personal liberty, and the people who are committing the suicide, they must not be punished. Decriminalization of 309. That is what the argument was. So make it decriminalization of section 309. But 2 years later, this was 1994 case. 2 years later, the matter was again challenged in GP Kaur, or it is known as Gyanpal Kaur, right, versus State of Punjab, where Supreme Court again in 1996 reversed its judgment. Reverse means they had again validated that 309 is fine, and if somebody found to attempt suicide and he or she is surviving, then he or she may be punished up to 1 year jail term. That means reversal of the judgment. So basically, the Ratinam was a division bench case. Division bench, you know that, two-judge bench, and Gyanpal Kaur was a constitutional bench where 5 judges were there. So they can easily reverse, you know that. Revisory jurisdiction can be exercised. And if a judgment given by lower bench is there, higher judge bench can reverse it. So there they have reversed it. I mean that the story goes for. So what is the present situation? If somebody found to commit suicide, then probably if he or she survives, then he or she would be liable to be punishment. And somebody is found indulged in abetment of suicide, then they will be punished under section 306, which the punishment may go up to 10 years.